They could not have read the cases anyway. Very strange.
As soon as we get Irvine here, I'll grab this mic and do the introduction back and just put the mic in front of you when you speak. I'm Professor Rick Hassan of UCI Law. I'm so pleased that many of you could make it here in person to this event, and that many more of you are watching this via webcast. Each year, the Supreme Court decides fewer than 100 cases, but those cases can have a major effect on areas of public policy, ranging from criminal law to the environment to sexual freedom to immigration to the law of politics. The Court just completed its October 2011 term, deciding 75 cases. Last year was the first year of our annual review, and during that review, the panelists commented on the dullness of the term. Dahlia Lithwick called it a low-carb end to a sleepy term. What a difference a year makes. This year we have major decisions in a host of areas, from healthcare law to immigration to the First Amendment to criminal procedure. As the term ended, we also saw an unusual amount of leaking from the court about discord among the justices over Chief Justice Roberts' supposed change of vote in the healthcare case. One of the most recent articles on that palace intrigue comes from one of our panelists, Marcia Coyle. Next term promises to be another potential blockbuster with likely decisions on affirmative action, the constitutionality of the Voting Rights Act, and much more. So stay tuned for details for the third annual UCI Term in Review. To help us sort out what happened last term and maybe what's likely to come in the coming term, we have an all-star panel of Supreme Court experts, some of whom come great distances to be here with us today. In alphabetical order they are Jess Braven. Jess became the Wall Street Journal's Supreme Court correspondent in 2005, following postings covering the United Nations and national legal affairs, and editing the weekly WSJ California section. He's the author of Squeaky, The Life and Times of Lynette Alice Fromm, a contributor to books including Crime of Wars 2.0 and Violence in American Encyclopedia, and a lecturer at the University of California, Washington Center, where he teaches a course on the Supreme Court. He received the American Bar Association Silver Gavel Award for his coverage of law and terrorism after 9/11, and the UN Correspondents Association Elizabeth Nuffler Memorial Prize for reporting on the International Criminal Court. Jennifer Chaconne is a professor and former Senior Associate Dean for Academic Affairs here at the University of California at Irvine School of Law. Her scholarship is focused on the nexus of immigration law and criminal law. She's examined U.S. efforts to curb human trafficking, anti-gang initiative launched by the Federal Immigration Enforcement Agency, and the implications of framing immigration enforcement as a national security issue. In addition to her scholarship and teaching, she has served as an outside advisor for the immigration transition team of President-elect Barack Obama, and the convener of the Immigration Policy Advisory Committee for Barack Obama's presidential campaign. Herman Chemerinsky is the founding dean and distinguished professor of law at the University of California Irvine School of Law with a joint appointment in political science. Previously taught at Duke Law School for 4 years, during which he won the Duke University Teacher Scholar of the Year Award. Before that, he taught for 21 years at the University of Southern California and served for 4 years as the director of the Center for Communications Law and Policy. His areas of expertise are constitutional law, federal practice, civil rights, civil liberties, and appellate litigation. He's the author of 7 books, most recently The Conservative Assault on the Constitution. Marcia Coyle is the chief Washington correspondent for National Law Journal, a national weekly newspaper that covers law and litigation. Marcia, a lawyer as well as a journalist, has covered the Supreme Court for 25 years. She's also a regular contributor of Supreme Court analysis to PBS's NewsHour. Before joining NLJ, she covered state and national government and politics for the Pennsylvania Times-Mirror Daily newspaper for more than a decade. Besides her work for the Law Journal, she's written about the Supreme Court and other legal issues for publications such as Vogue, Ms. Magazine, and the New York Times Book Review, and she's a contributing author to a book on the Supreme Court, A Year in the Life of the Supreme Court. Her reporting has garnered National Journalism Awards such as the George Polk Award for Legal Reporting, the Investigative Reporter and Editor's Award for Outstanding Investigative Reporting, the American Judicature Society's Tony House Journalism Award for a career body of work involving coverage of the nation's courts and justice system, and the Scripps Howard Foundation Award for Environmental Journalism. Robert Pushaw is the James Wilson Endowed Professor of Law at Pepperdine Law School in Malibu, California. After graduation from Yale Law School, Bob clerked for Judge James Buckley of the United States Court of Appeals for the D.C. Circuit, and then worked at Davis Wright Tremaine in Seattle. Joining the University of Missouri Law faculty in 1992, Professor Pushaw taught constitutional law, federal courts, contracts, and estates and trusts. In 1998, he won the Blackwell-Sanders Distinguished Faculty Achievement Award as the school's top teacher. In 2000, Pushaw received the William Kemper Fellowship for Teaching Excellence, the University of Missouri's highest teaching honor. He arrived at Pepperdine in 2001. His scholarship focuses on the influence of 18th century Anglo-American political and legal theory on the development of modern law governing the Constitution, especially the Commerce Clause, and federal courts, particularly the justiciability doctrines and inherent judicial powers. At the University of Missouri, he twice earned the Shook, Hardy, and Bacon Excellent in Research Award. A very distinguished panel. The format for today's event is as follows. I'll give each panelist about 8 minutes to speak on 2 topics. First, the theme of the term, or overall impressions of the term, and some thoughts on an interesting or important case of the term. We've divided these up to get some breadth of coverage. After this first round, we'll have some give and take with the panelists, and then we will open it up to questions. This will leave us with about a half an hour for questions. We'll be taking questions from the audience, as well as if you want to post a question, if you're watching on the webcast, you can post on Twitter using the hashtag UCI Law SCOTUS. If that doesn't mean anything to you, you can send an email to me at rhasen@law.uci.edu. With that, I'm going to turn it over very briefly to Dean Chemerinsky to welcome everyone, and then to our panelists. And please join me in thanking the panelists for coming.
Thank you so much, Rick. I want to take a moment to welcome all of you to UCI Law School. Also want to share some news that we received yesterday. On the LIDA report, there was a link to a major study that's just been done about faculty scholarly impact. And UCI Law School is ranked number 7 in the country of all law schools. We're behind. Ahead of us were Yale, Harvard, Chicago, Stanford, NYU, and Columbia. So it's a wonderful company to be in, and it's certainly a reflection of my colleagues, Jennifer and Rick, and many others who are in this room. I want to take just a moment to thank Rick Hassan, who's really responsible for organizing this panel. It's become a key part of the law school, and one that I hope we'll continue to do every summer for a long time to come. I want to thank Brittany Rodriguez, who did so much with regard to the planning and logistics of this event. I want to thank my colleagues on the panel, especially those who have come such a long distance to be part of this discussion. And I want to thank all of you for being here today. We have over 250 people today coming to this, which I think is the largest event we've yet had at UCI Law School. So it's very special for us.
Oh, excuse me. All right. Hello? Okay. Well, it's a political year, so I thought I would start by pandering to the crowd. When I attended one of the sister UC law schools, I held the student seat on the Board of Regents, and I voted against the student professional fee differential for law schools and against all other fee increases, so I hope that buys me some sympathy today.
Not from me.
And I was outvoted, so and I was not as disputatious as some recent officials who were outvoted in one of the matters we might discuss today. As we said, it is a political year, and we saw at the end of the term, as Rick mentioned, the Supreme Court acting more like a political institution than we've seen in a long time, and that was from the remarkable and impressive leak that Jan Crawford of CBS News reported with the complaints from conservative dissenters in a healthcare case about the vote and the behavior of the Chief Justice in that case. And I certainly know that as a reporter covering it, I hope this would open a new day of transparency and politically and spitefully motivated leaks coming from the Supreme Court. But unfortunately, that has not yet fully come to pass. Marcia had a nice story the other day with some very genteel leaks or quotes from the court to justices saying that they will patch everything up in the fall, just as they did after Bush v. Gore and other things. And that's certainly true. When you have 9 members of the court and 5 to have a majority, it's not like the House of Representatives where you can have a grudge and it doesn't really matter because there are hundreds and hundreds of you. They have to work together, and they will for many years. And so we will certainly see people who might have been talking smack about each other this month having to make some kind of accord, at least in writing, in the future. But the political messy end, and I say political in the sense of accusations of vote switching and betrayal and that kind of thing, that in some ways does complement the fact that the court was involved this year in many highly charged political issues, where we had the last year being a snoozer, except of course for the distinguished faculty in ERISA studies, the Employee Retirement Security and Something Act, which makes up a strangely disproportionate number of cases on the docket. There wasn't that much. But this year, of course, we had the court involved in many of the toughest issues that befuddle the political branches as well. And while, of course, the focus is on the healthcare case that we saw at the end and the 5-4 vote and the the affirmation of, I guess, what we will now refer to as Roberts care, it does mask somewhat the fact that the court, as it evolves into what we will eventually capitalize the noun as the Roberts Court, we did see throughout the term a progression to the broad goals that the Chief Justice stated when he was applying for the job back in 2005. And while the attention has been on Roberts perhaps moving to the left in a unique way to affirm the Affordable Care Act, if you look at some of the important decisions earlier in the term, what we saw was really the liberal wing of the court moving towards the Chief Justice, at least for his goal of the court speaking in unanimous or near unanimous opinions. And so I think it's for the context, as we try to look at the themes of the court, we should step back and look at some of those other cases, some of which we'll talk about in more detail here. But we saw as well the same week a 6-3 vote on the immigration case, which was more than perhaps I'm sorry, not 6-3 case, 6-3 vote. Forgive me. It was a unanimous vote on the immigration case. What do we have? Is that one? 5-3. 5. All right. Sorry. Let me back up for a second, and for those of you in the Twitter universe who've unfortunately sent a tweet and then regretted it, you'll understand. But to move back, I think we should look at for example, the Hosanna Tabor case involving the ministerial exception that the court recognized in employment discrimination law, which was a unanimous case. The Sackett versus EPA case, which found a requirement in the Administrative Procedure Act for the EPA, an EPA compliance order being a final agency action, and thereby triggering the right of the property owner to go to federal court to challenge it. Those were unanimous decisions, and ones that not necessarily one would have expected to have the liberal wing of the court completely joining in with the conservative majority. But we saw there, for whatever reason, I mean, one could imagine many arguments that Justice Ginsburg might have offered in at least writing a separate concurrence in the Hosanna Tabor case. This is the one that found that ministers and those regarded as ministers by religious institutions are not covered by employment discrimination laws and have no remedy under federal law because of the Establishment Clause prohibiting the government from interfering in the organization of a religious institution. So one could have imagined some gloss on that coming from the liberal wing of the court, but there wasn't one. It was a unanimous opinion, and similarly with the EPA case, and we saw that in a number of decisions. We even saw unanimity in a case, the FCC versus Fox, which was the language indecency case. The court had a couple of years ago sent this case back on a 5-4 vote to the Second Circuit, which had ruled there was a violation of the Administrative Procedure Act when the FCC issued a ban on fleeting expletives on broadcast television. The court it went back to the Second Circuit, which did exactly what it said it would do. It found that same rule unconstitutional, much as it had found it a violation of procedure. We expected the court to rule on the constitutional issue regarding indecent language over the airwaves, and instead they ducked it. It almost as if they reconsidered their first version because it found a procedural reason to affirm the Second Circuit without reaching the constitutional issue, and that was a 9-0 opinion, and perhaps that reflected a desire not to have another dispute on the court. So we should look at the fact that the court has in many ways spoken with greater consensus than one might have expected if you only looked at, say, the last day of the term. Now let me talk, though, about one of the cases where the court did not find unanimity, and that, as we said, we've divided up some of the more interesting and amusing highlights. This is one that, had it been in the previous term, would be the thing we'd all be talking about endlessly, but because it's a relative, we grade on a curve, and last year it would have been a very big deal. This year it's sort of a moderate one. This is the strip search case, which the court heard earlier in the term, and the question arose about whether it is a violation of the Fourth Amendment for jailers to have a blanket policy of strip searching every person who's taken into a jail. And this arose in Burlington County, New Jersey, where a state trooper arrested a man named Albert Florence, and Mr. Florence was arrested in error. There was a warrant still in the system saying that he had failed to pay a fine, which triggered his arrest, but in fact he had paid the fine, and the New Jersey computer record system failed to correct it. So he was arrested completely in error, although it was one that was understandable from the officer's point of view. He was taken to jail, and he was strip searched when he entered the Burlington County Jail, and later when he was transferred to the Essex County Jail, he was strip searched again. Now, he had many claims against the New Jersey justice system, such as, being locked up in jail for a week when you hadn't done anything. But the case that he brought that got the attention, went to the Supreme Court, dealt with really only a few minutes of that week-long erroneous incarceration. And and distributed a story I did, which looks at some of the reasons of that. And I found this case of interest. I found this case of interest for. I'll get to return to it later on, perhaps. But for this reason principally, we've all or heard of at least Gideon's Trumpet, which talks about the Gideon versus Wainwright decision and some of the many heroic ways that cases get to the Supreme Court. Well, the Florence case, Florence versus Board of Freeholders, also has a very interesting backstory and how it got to the Supreme Court, but it is somewhat different. The story of how that happened is Brittany reproduced it in color for you here if you want to take a look, and perhaps we'll get back to it a little later. So, all right, I've run over my time. Off to Jennifer.
Good afternoon. Thank you all for coming, and thanks to Rick for organizing, and to Irwin, as always, for everything he does to make these things happen. We were asked to think a little bit about how to describe this term, and so I thought, when I was thinking about the court, I agree with Jess. I think this was ultimately a year of preserving institutional legitimacy through a sort of surface moderation that I think doesn't really attempt to hide some deeply conservative underpinnings. I think that we'll look back at this year, particularly the end of this year, and see the beginning of a new era. But I'm not sure what this era is or what it portends. So I think we see plates shifting, and we know that the earth is about to shake or it's shaking, but it's not clear where we'll land. So that's my soothsayer way of not saying anything at all about where I think we're going. But I want to illustrate this by looking at three slightly more specific points. In the area of criminal law, I thought one significant trend that I'd like to hear some panelists talk more about is the court's growing efforts to focus not just on the courtroom, but on criminal pleas. Two cases of note in this regard, Lafler versus Cooper and Missouri versus Fry, involved ineffective assistance of counsel claims that were extended to plea agreements that defense counsel either improvidently rejected or allowed to lapse. And these were interesting to me mostly because it was an immigration case from a couple of terms ago, Padilla versus Kentucky, that helped to bring us to this critical point, with the court looking with more attention to the plea bargaining stage. And I think this in some ways sheds light on the ways that immigration law and criminal law are becoming increasingly intertwined and influence the jurisprudence of one another. And that obviously has relevance for the case of United States versus Arizona, which I'll talk about in a little bit. In the area of criminal procedure, I think we continue to see the grim times for the erstwhile criminal procedure revolution in cases like House versus Fields, which limits, again, in creative ways, the definition of what constitutes custody for purposes of Miranda. In Messerschmitt versus Millender, which further erodes protections against general warrants, and the Florence case that we just heard about. I think the notable exception to this is the case of Jones, which I think someone else on the panel will talk about with a 9-0 decision, that I still think doesn't offer a particularly novel or new kind of rights protective vision of the Fourth Amendment, but is definitely worth highlighting. Finally, in immigration law, I know the case everybody wants to talk about is Kawashima versus Holder, of course, finding that the preparation of a false tax return is an aggravated felony under 8 U.S.C. 1101 A43M, right? That's the case that has everybody buzzing, and so that's what I'll be focusing my remarks on today, or maybe not. There were several statutory cases in immigration law, including one that involves an equal protection challenge to a citizenship derivative citizenship provision that highlights the kind of the still backward states of many aspects of immigration law. But the big case in immigration, obviously, was U.S. versus Arizona. In this case, of course, involved the federal government's challenge to the, quote, Support Our Law Enforcement and Safe Neighborhoods Act. The Arizona legislature has not yet gotten the hang of the catchy acronym type of law, so they refer to this not as SALLISNA, but as SB 1070. Judge Bolton of the Federal District of Arizona issued an injunction of SB 1070 in July of 2010 that prevented 4 of the key provisions of the law from going into effect on the ground that they were preempted by federal law. On April 11th of 2011, the Ninth Circuit affirmed, and Arizona appealed the case to the Supreme Court. On June 25th of 2012, the Supreme Court issued its widely anticipated decision in the case. And I would say the decision, one of the things that was notable when the court handed down its decision is that both sides ran around proclaiming victory very loudly, and beneath that kind of din of proclamations of victory, there was some hand-wringing on both sides. I think that both that my kind of take on what happened in that case, the way I would describe it, is that on the whole, it's a pretty solid legal victory for the federal government because of its broad reiteration of federal powers in regulating immigration, its fairly robust application of obstacle or conflict preemption to state immigration laws, and its clear rejection, and I think this is important, of the new and voguish mirror image theory, whereby states have attempted to avoid findings of preemption of their immigration regulations by arguing that their laws merely mirror the federal scheme and thereby can't be preempted. So I think the court, in rejecting that, handed a strong legal victory to the federal government. That said, on the ground, I think this decision will not have the effect of preventing the harms that many of the proponents of the lawsuit were hoping to avoid, and I think that's a kind of an important takeaway from this that's also important to recognize. So I want to unpack this decision a little bit more if I have time, and I think I do. I have 3 minutes to unpack this a little bit more, and then I'll wrap up and turn this on. As I said, I think read as a whole, I think this reads as a legal victory for the federal government in many regards. Of the 4 challenge provisions, 3 of them were held to be preempted. There was Section 3, which criminalized failure to comply with federal alien registration requirements. There was Section 5C, which would have criminalized employment without federal authorization. And there was Section 6, which would have authorized state officials to make warrantless arrests of individuals where the officer had probable cause to believe that the person had committed an offense that rendered him or her removable under federal immigration law. And we can get more into the weeds of these provisions if people want to during the Q&A. So those are the provisions that were struck down. Section 3, the alien registration requirement, relying on Hines versus Davidovitz, an older case that struck down similar alien registration requirements from Pennsylvania in the late 1930s or 1940. Section 5C, the employment provision, struck down on the ground that IRCA, the Immigration Reform and Control Act of 1986, was a comprehensive scheme governing the employment of unauthorized workers, and that this scheme of Arizona's conflicted with it, created a conflict with a federal scheme. And Section 6, authorizing state officials to conduct warrantless arrests, the courts found exceeded the authority that even federal immigration officers had to make arrests and ran the risk of being in tension with federal immigration priorities and resulting in harassment of individuals. So these provisions were held to be preempted. The provision that was spared, however, was Section 2B. This was the most controversial provision of the law. It requires state officers to make a reasonable attempt when practicable to determine the immigration status of anyone who's been otherwise lawfully stopped, arrested, or detained. And it requires that any person who is arrested shall have their immigration status determined before they are released. It's notable, and I think important to stress, that this provision was given a narrow reading by the court when they upheld it. They assumed, for the purposes of their conclusion, that any stop or arrest would not be prolonged by an immigration status inquiry. They declined to reach the issue of whether an otherwise lawful detention could be prolonged lawfully on the basis of reasonable suspicion of illegal entry or some other immigration crime. And they nowhere suggested that prolonging an otherwise lawful detention could be justified on the grounds of suspected civil immigration violations. So it left open the door to a host of Fourth Amendment challenges that might arise in the implementation of the law. It left open the door to possible challenges as well on preemption grounds if in the implementation of the law, Arizona's implementation is in conflict with federal priorities. But I think perhaps most importantly for opponents of the law, the decision offers a strong restatement of federal primacy in the regulation of immigration law, along with a Spider-Man-esque invocation from Anthony Kennedy that with great power comes great responsibility, urging the federal government to use its powers wisely. On the other hand, as I said, the decision leaves the door open for some federal immigration regulation. It's likely to encourage more jurisdictions to enact provisions like Section 2B. It greenlights state and local law enforcement participation in immigration policing in ways that I think will result to almost a certainty to some degree of racial profiling in various jurisdictions across the nation, and certainly increased litigation around these issues. So that's what we can expect to see in immigration, I think.
I think it's now become the John Roberts Court. For the 7 years in which John Roberts was Chief Justice, in almost every ideologically divided case, Anthony Kennedy was the swing justice. So it was easy for me and others to say this was really the Kennedy Court. It was easy to just group Roberts together with Scalia, Thomas, and Alito as the conservative wing of the court. But 3 times in the last week, John Roberts was part of a majority primarily comprised of the liberal justices. He's now written the most important opinion in the decisions of his 7 years as Chief Justice. That's why I think we can now think of this much more than ever before as really being the Roberts Court. Now, I don't want to lessen the description of the importance of Anthony Kennedy on the court. Kennedy was in the majority this year more than any other justice, 93% of the time. But the justice next most often in the majority was John Roberts, 92% of the time. Also, this term, there were 16 5-4 or 5-3 decisions. The justice most often in the majority was Anthony Kennedy in 12 of those decisions. But I think that there is an important effect of having 2 swing justices rather than 1 swing justice. For the last 7 years, if you describe the past 6 terms, overall, the conservatives have prevailed much more often than the liberals. Kennedy sides with the conservatives about 75% of the time when the court is ideologically divided 5-4. But now you have 2 different justices who might join with the liberals. There were certainly important conservative victories this term. Wrong to regard it as overall a liberal term. But there were more important liberal victories this term than any of the prior 6 years of the Roberts Court. And I don't know if this predicts what will be in the future. We can't know until we have many more terms from now. But it does make this year, ideologically, much more mixed in results than we've seen. One other statistic I'd mention by way of overview that hasn't been said, the court decided only 65 cases this term after briefing and oral argument. That's the fewest number in many decades. The last 2 years, it was 75 cases each. For much of the 1980s, the court was averaging over 160 cases a term. For much of the 20th century, the court was averaging over 200 cases a term. And now it's just down to 65. To put it another way, for the entire term, John Roberts wrote 11 opinions that counts majority, concurring, and dissenting opinions. For the entire year, both Anthony Kennedy and Lady Kagan wrote 12 opinions. That includes majority, concurring, and dissenting opinions. I assure you, if you talk to any judge At any level of court, they would love the idea of having read 11 or 12 opinions for the entire year. It does continue to have a very pernicious consequence. As the number of decisions has gone down, the length of the opinion has gone dramatically up. The opinion in the Affordable Care case is 193 pages long. There were many opinions this term that were 100 pages long. I think we need to start a campaign for word and page limits on the United States Supreme Court.
I think we'd agree with that.
I was asked to talk about the two free speech cases of the term. One is United States versus Alvarez. It involves the federal Stolen Valor Act. It's a federal law, makes it a federal crime for a person to falsely claim to receive military honors or decorations. The law is very broad. It doesn't have an intent requirement. So if a person makes a mistake, saying, I won the Medal of Honor, but it was really the Purple Heart, that would violate the law as written. The lie doesn't have to be publicly uttered. If somebody, say on a date to impress, claims to have received the Medal of Honor, that would violate the law. In fact, even fictional depictions like Forrest Gump would violate the law as written. Case involves an official in a water district in Claremont who was, in the words of Justice Kennedy, a habitual liar, and he claimed to have won the Medal of Honor. He didn't. Local newspapers and blogs quickly exposed this and ridiculed him, but the United States attorney indicted him for violating the Stolen Valor Act. The Supreme Court, in a 6-3 decision, without a majority opinion, struck the law down. Justice Kennedy wrote for a plurality. His opinion was joined by Chief Justice Roberts and also Justice Ginsburg and Sotomayor. Justice Kennedy said, this is a content-based restriction on speech. It thus has to be subjected to the most exacting scrutiny, which is allowed only if it's necessary to achieve a compelling purpose. So the government can't prove that it's been hurt by any of these lies. There's other less restrictive alternatives. Maybe in the most important part of this opinion, he said, there's no categorical exemption to the First Amendment just because people are lying. He said there's certain areas where false speech can be punished. False and deceptive advertising isn't protected by the First Amendment. False defamatory statements are generally not protected. But he rejected the government's argument that just because something is false is without First Amendment protection. Justice Breyer concurred in the judgment joined by Justice Kagan. He said he would use a lower level of review, what's called intermediate scrutiny, but he said the law was not sufficiently narrowly tailored to meet First Amendment review. The other free speech case I want to talk about, I think, is even more important. In fact, I regard it as one of the sleeper cases of the term. It hasn't gotten much media attention, but it's going to have an enormous practical political impact. It's a case called Knox versus SEIU. In 1977, in a Abood versus Detroit Board of Education, the Supreme Court said if there's a public employee union, nobody can be forced to join. But non-members can be required to pay the portion of the dues that go to support the collective bargaining activities of the union. The non-members are still benefiting from collective bargaining in terms of pay, work conditions, hours, so they should have to pay for the collective bargaining. But nobody can be forced to pay for the political activities they don't want to. And the process then developed that if somebody doesn't want to join a public employees union, they can opt out of supporting the political activities. In Chicago Teachers versus Hudson, the Supreme Court said each year a union should give non-members an accounting as to the percentage of dues that went to collective bargaining they have to pay versus the percentage of dues that were going to political activities, and they can opt out of the latter. Knox versus SEIU arose, you might remember, several years ago in California. Then Governor Arnold Schwarzenegger successfully got on the ballot a couple of initiatives that would have greatly lessened the influence of public employees union. The SEIU, that represents many public employees in the state, organized a campaign to defeat them. The SEIU was successful in defeating the initiatives, and the SEIU imposed an assessment on the members, both members and non-members of public employee unions, to pay for the campaign. The issue that was briefed and argued to the Supreme Court was whether or not the SEIU had to give the non-members of notice so they could opt out of supporting the political campaign. But that's not how the Supreme Court decided the issue. Justice Alito wrote for a 5-person majority. He was joined by Chief Justice Roberts, Justice Scalia, Kennedy, and Thomas. And he said it violated the First Amendment because the non-members should have been required to opt in if they wanted to support the political campaign. In other words, at least with regard to the special assessment, opting out wasn't good enough. They would have to opt in. As Justice Sotomayor said in her opinion concurring the judgment, as Justice Breyer said in dissent, this is a major change in the law. It wasn't briefed or argued to the Supreme Court. To try to understand why this matters so much, the best metaphor I can think of is Book of the Month Club or Columbia Records. How did they make all their money? Well, once you sign up, you are then charged for the book or the CD unless you choose to opt out. Had they been an opt-in system, maybe they wouldn't have financially survived. They certainly made a lot less money. What this is going to mean if non-members always have to opt into supporting political activities is a tremendous lessening in the political influence of public employee unions in the United States. Combine this with the Supreme Court's decision a couple of years ago in Citizens United versus Federal Election Commission, which tremendously increased the political influence of corporations. And I think you can see why I say this is the sleeper case that's going to matter so much.
I'd like to thank you for inviting me here. I'm very happy to be here today, especially since I looked at the temperature in Washington, D.C., which is about 100. But nevertheless, I'm very happy to be here. I wanted to pick up on something Dean Chemerinsky said about this being the Roberts Court. I had this interview not too long ago with a certain justice, and it was off the record, so I can't tell you who the justice was, and I probably shouldn't even tell you this little anecdote, but we'll call the justice he who shall not be named. Thank you, Harry Potter, for that. And this justice said he didn't understand why Supreme Courts are named after their Chief Justice. He said, why should William Rehnquist be blamed for what that court did? Instead, he suggested that courts should be named after the president who appointed the last member of the Supreme Court, which would make this the Obama court. Now, it may be that the president is willing to embrace this court after the last day of the term, but I'm not so sure he would fully embrace the Roberts Court right now. I agree with everything everybody has said about the assessment of the court thus far, as I've ticked off the points I wanted to make that everybody else has made. But I would like to just also point out that this was an unusual term, I think, for Justice Scalia. He's never been shy about stating his feelings in oral arguments or in his decisions, but in a sense he was almost, I mean, could you say Scalia unbound as one of the themes this term? Because he made comments from the bench that attracted a lot of attention because of their political nature, almost their bias in terms of the parties that were arguing for them. And that was most notable in the immigration case, the Arizona immigration case, and also in the healthcare case. Also, I noticed that, and this goes with the theme of greater unanimity, greater consensus, that there were really a lot more shifting alignments among the justices than we had seen in the past. For example, Justice Sotomayor led the Chief Justice and Justices Scalia, Thomas, and Alito in a bankruptcy decision, and I know it's dull and it probably isn't one of the most important cases of the term, but it was to the owners of a farm.
There's some bankruptcy judges sitting right there.
Oh, sorry. But it was very important to people who care about that chapter of the bankruptcy code. Those same four conservatives joined Justice Breyer in his majority opinion in a case involving the Internal Revenue Code, and there was movement in the other direction as well. Justice Breyer joined Justice Alito's decision in Williams versus Illinois, which is a confrontation clause case. While Justice Kagan's dissent was joined by Justices Scalia, Ginsburg, and Sotomayor. And then, of course, the granddaddy of surprising alignments occurred in the healthcare decision, which I know Professor Pushaw is going to talk about. I also wanted to point out that Justice Kagan continues to expand the court's modern legal vocabulary. Last term, she introduced the words ditto and loosey-goosey in decisions. And this term, she said that the majority's approach in the Confrontation Clause case would make constitutional giga of the Confrontation Clause. There's this wonderful website, and I don't have it for you, where you can actually plug in a word, and it has all of the Supreme Court decisions going back almost 100 years, but it stops with the Rehnquist Court to see how often that word appears. And she's got loosey-goosey nailed. I picked a case to talk about that was one of the bigger cases of the term and was not an example of unanimity or greater consensus, and that was the case involving the sentence of mandatory life in prison without parole for juveniles who commit murders. And this was really two cases, and it involved two young men who were 14 at the time the murders were committed. And the main difference between the two was one of the 14-year-olds at the time was not actually the murderer per se. He was involved in an attempted robbery that turned into homicide. He was not the trigger person. But both of them received mandatory sentences of life in prison without parole. And I picked this case because, one, this case was assigned to the majority opinion. It was a 5-4 decision. The majority opinion was assigned to Justice Kagan, which is probably her most important decision since she's been on the court. And it was assigned to her by Justice Kennedy. The Chief Justice and Justice Scalia were both in dissent, which then left to whoever was the most senior justice in the majority, and that was Kennedy, to do the assigning, and he gave it to Justice Kagan. And the other reason I picked it was that we often don't get a chance to explain in any depth that the Supreme Court rarely writes on a clean slate. And this case is a good example of how Justice Kagan saw two lines of Supreme Court precedent coming together to reach the decision that there should not be mandatory sentences of life in prison without parole for juvenile murderers. The first line of precedents that she saw began fairly recently. In 2005, the Supreme Court took off the table the death penalty for juveniles. And then just the term before the one that just ended, the court took off the table life in prison without parole for juveniles who commit non-homicide crimes. So she drew from that youth matters, and those opinions talked about the culpability of young people, the lack of maturity, and all the scientific tests we've seen recently about that frontal lobe not maturing that explains why my children act the way they act. The second line of precedent had to do with the death penalty, where the court has said that if you're going to impose something as serious as the death penalty, you have to have individualized consideration. You can't just have a mandatory penalty. Well, she took from that life in prison without parole for juveniles is really analogous to the death penalty. They were going to die in prison. And so between youth matters and the need for individualized consideration, she found, and the majority found, that the mandatory nature of this penalty should be taken off the table. Judges still can impose life in prison without parole, but they have to look at the nature of the individual and the nature of the crime. She also hinted in her decision that she thought that life in prison without parole for juveniles, even if it's not mandatory, is going to be a rare sentence. The dissenters looked at this very differently. The Chief Justice wrote the main dissent, and he fell back on, what does the Eighth Amendment say? It says, it bans cruel and unusual punishment. And he found there was nothing unusual about this punishment. 29 states had mandatory life in prison without parole for juveniles. And he also did some statistics on how often it's imposed. Justice Kagan came back and said, well, really, the 29 states is less than the number of states that had the death penalty, for juvenile, or life in prison without parole for juveniles who didn't commit murders, and so she felt the weight still was on her side of the opinion. This was a good example also of, I think, some of the more important criminal cases this term that were briefly mentioned, where the liberals on the bench did quite well. There was the Sixth Amendment case involving effective assistance of counsel at the plea bargaining stage. The court said you are entitled to an effective lawyer if a plea bargain is not offered, the lawyer fails to offer the bargain that the prosecution puts on the table. Also, there were 2 cases involving crack cocaine. There's a fairly recent law called the Fair Sentencing Act in which Congress tried to deal with the racial disparity in those who are convicted of crack offenses versus those who are convicted of cocaine powder. Crack offenses are considered a minority offense. Cocaine powder is the drug of preference for white people. And so the act reduced that disparity. What it actually did was it made the sentence more lenient. But the question before the court was kind of narrow. It had to do with people who were convicted before this act took effect, but were sentenced after. Was the act going to apply to them? And the court found that yes, it would, because Congress wanted to lessen the disparity. And then also there was the GPS case, which was a unanimous case, and in which all of the justices found that it is a search under the 4th Amendment to have police attach a GPS unit to your car. And then another case was 6-3, and that involved applying a line of cases involving sentencing where this case involved criminal fines, and the court said that any fact that increases a potential fine that a defendant faces upon conviction must be found by a jury beyond a reasonable doubt. And the court had applied that theory to criminal law mandatory sentences that judges used to be able to go above the mandatory sentence in their own discretion, but now juries have to find that. Now it's going to apply to criminal fines as well. This was a corporate case, and I'm sure corporations were very happy to hear that. So it was a very important term for criminal decisions, and they did go more to the liberal side than to the conservative side.
My fellow panelists agree that this term, John Roberts, made the court his own and achieved greater consensus. That may be correct as to trivial cases, and is sometimes true even in constitutional decisions like Jones. But the image of a consensus building Roberts court shatters in cases raising the big constitutional issues like affirmative action, campaign finance reform, and abortion. The court's divisions are clear. On one side, you have 4 conservative Republicans who have 4 main goals. First, cut back on liberal individual rights precedent, especially in the areas of criminal procedure, privacy, and equality. Second, limit Congress's power and narrowly interpret liberal statutes like environmental laws. Third, promote business. Fourth, decrease litigation. On the other side, you have 4 liberal Democrats who take the opposite positions. Typically, Justice Kennedy breaks the tie, although sometimes it's Roberts. Political and ideological factors have become paramount because modern constitutional law is about policy, not the Constitution as intended and understood. Constitutional decision-making is a form of common law. The court creates a doctrine that strikes the majority as wise policy, and then they tweak it case by case. Unlike real common law, however, there ain't no legislative override if the court gets it wrong. Therefore, maybe it's good that the court is so polarized, because that keeps either side from going off the deep end. But it means we don't really have a court, an institution striving to find common ground in interpreting and applying the Constitution as law. Rather, we have 9 justices doing their own thing. The court's decision on the Affordable Care Act, the ACA or Obamacare, illustrates these points. Roberts wrote an opinion that no one else joined in full. The 4 conservative Republican appointees bitterly dissented, and Justices Ginsburg and Sotomayor expressed alarm that the court imposed any limits on Congress. So what does the ACA do? Well, it forces insurance companies to issue medical insurance to all applicants. To help insurers stay afloat, uninsured Americans must obtain minimum coverage, and if they defy this individual mandate, pay a penalty to the IRS. The ACA also dramatically expands Medicaid by requiring states to provide health care to all citizens who fall below a certain income level. Before examining the ACA provisions, the court unanimously ruled that the Anti-Injunction Act, which prohibits federal courts from enjoining the assessment or collection of any tax, did not apply. Why? Because the individual mandate was not a tax, it was a penalty for violating the legal mandate to buy health insurance. The court then fractured as to whether Congress had constitutional power to enact Obamacare. First, Roberts and his four fellow Republicans concluded that the individual mandate could not be sustained under the Commerce Clause, which authorized Congress only to regulate existing commercial activity, not to compel Americans to buy an unwanted product. The court also reaffirmed its Lopez holding that the activity Congress can regulate must be commercial in nature. These limits, however, hang on the vote of one justice. The four liberals are not on board, so if a Democratic appointee replaces a Republican one, these cases will be overturned. Second, Roberts joined the four conservatives, plus Breyer and Kagan, to rule that the Medicaid expansion exceeded Congress's power under the spending clause by coercing states to obey federally imposed conditions. This holding is surprising because since 1937, the court has rejected every challenge to the spending power. So the court's identified limits on that power seem to be theoretical. The Medicaid expansion, however, was extreme. Congress threatened to withdraw all federal funding, a huge amount, whereas previous cases had established that a 5% reduction involving relatively small change was permissible. Thus, the court will now have to determine case by case how much withholding goes too far. Third, and shockingly, Roberts agreed with the four liberals that the individual mandate could reasonably be interpreted as a tax on those who would forego health insurance and hence could be upheld under the taxing power. This ruling confirmed the court's post-1936 precedent that the taxing power has no real limits. But this undermines the court's effort to restrict Congress's other powers and thereby revive the principle that the Constitution limits the federal government to its enumerated powers and reserves all other powers to the states. This disregard of federalism is troubling enough when Congress actually exercises its taxing power. It is far worse when Congress declines to do so, but then the court construes the legislation as a tax anyway. Why is this a problem? Because it destroys the only restraint on the taxing power, that voters will not tolerate tax increases above a certain level. In the ACA, Congress explicitly declared that the mandate was not a tax, but rather a penalty. Indeed, that's why all the justices concluded that the mandate was not a tax under the Anti-Injunction Act. Only through legal mumbo-jumbo did the majority magically transform the mandate back into a tax for constitutional purposes. The Roberts Court thereby missed an opportunity to issue a transformative opinion. Beginning in 1937, the court dismantled the Constitution's Federalist structure and embraced centralized government control of the economy and social welfare. That move has created huge problems, and the court could have addressed them and given federalism legal teeth by invalidating the ACA. Indeed, Roberts himself was prepared to do so until he switched his vote in May. What was he thinking? Well, some have accused the Chief Justice of caving into political pressure from Obama and his supporters in Congress. the media and academia. A more flattering possibility is that the chief acted as a statesman to preserve the court's reputation as governed by law, not politics. Deference to the elected branches would be seen as judicial restraint. Unfortunately, any belief that the court could remain above the political fray was misguided. Finally, some have portrayed Roberts as a latter-day John Marshall in Marbury, who achieved his long-range goal of asserting judicial review, yet avoided a direct confrontation with the hostile Jefferson administration. Similarly, Roberts supposedly handed the Democrats an immediate victory, but advanced long-term Republican interests by curtailing Congress's power under the Commerce and Spending Clauses. I don't buy that analogy. For openers, Marshall and the Federalist justices faced impeachment if they came out the other way, whereas Roberts and his Republican colleagues could have done so and actually been applauded by most Americans who oppose Obamacare. And sustaining Obamacare will not produce the long-lasting gains desired, especially if a Democratic justice replaces a Republican. Another critical difference is that Marshall led a unanimous court, whereas Roberts wrote an opinion that no other justice joined in full. Finally, and most significantly, Marshall was a career politician. By contrast, Roberts was an appellate lawyer, striving to cobble together at the Supreme Court at least 5 votes, typically by crafting a centrist position that relies on hyper-technical legal analysis. The pragmatic goal is to win, even by making inconsistent or hair-splitting arguments. It hardly impugns John Roberts' integrity to suggest that he was acting as a skilled appellate litigator. That's what he is. It is not necessarily bad to have a legal technician crafting compromise opinions. Nonetheless, great Chief Justices like Marshall and Warren had a broad and coherent constitutional vision, and each individual decision reinforced that. By contrast, the Roberts court is playing small ball. Perhaps he will start hitting home runs if Romney becomes president and replaces some liberal justices with conservatives, but if Obama is reelected and replaces one of the conservatives with a liberal, the Roberts court is toast. Virtually all the 5-4 opinions are going to be overruled. It is unfortunate that constitutional law now depends on elections rather than fundamental legal principles, but that is our brave new world. Thank you.
I want to thank all of our panelists for their initial statements, and what I'd like to do before we turn to questions is just open it up if anyone on the panel would like to respond to anyone else on the panel. Go ahead.
Sure. I should probably run on my.
If you have something to say.
That I can't promise. Actually, a quick thought on each of the things that were said. In terms of the Fourth Amendment cases, I've long had a predictive principle that if the Supreme Court justices can imagine it would happen to them, then it violates the Fourth Amendment. If they can't imagine it happening to them, then it doesn't violate the Fourth Amendment. Notice the 2 Fourth Amendment cases this term. Putting a GPS device on a car is a search, but strip searching those in jail, even if they're wrong there, it doesn't. I want to say a word about the case Marcia talked about. I think it's going to change procedure in trial courts in a very fundamental way. I think now if a prosecutor wants to seek a sentence of life without parole for a juvenile homicide, there's going to need to be a penalty phase where the jury is going to have to find the aggravating factors warrant that. We've never had those penalty phases before, except in death cases. If you know me at all, I disagree with everything Bob said. 3 quick points. First, a theme of what he says is that the court was not interpreting the Constitution as law, that was policy choices, not what the Constitution intended. The Constitution was written in very broad language, using phrases like cruel and unusual punishment. It was written for a very different world. John Marshall said we must never forget that it was a constitution we're interpreting. Constitution meant to be adapted and endure for ages to come. The Constitution has always depended on judicial interpretation, and that's always dependent on who's on the court in presidential elections. There's nothing new. Second, he says that the court found the individual mandate as a tax, as I'll use his word, shocking. I didn't find it shocking at all. It made a great deal of sense to me. The individual mandate operates as a tax. It's calculated as a percentage of income or a flat rate. It's 1% of income or $95 in the year 2014. It's collected by the Internal Revenue Service. The funds go to general federal revenue, it'll be $4 billion in 2014. That seems to be a tax. Now it's true, the Obama administration didn't want to use that three-letter word that has such political consequences and connotations, but the Supreme Court had held in other cases that whether something is to be treated as a tax for purpose of Congress power doesn't depend on the label that's used. Now, Bob says, well, the court had to use, in his words, were mumbo-jumbo to make this not a tax for purpose of the Anti-Injunction Act, but a tax for purpose of Congress's power. Interpreting a statute is different than interpreting a constitutional provision. Something certainly could fit within the broad meaning of tax under Article 1, Section 8, even if it doesn't fit under the narrow meaning of a statutory word. Third, he says the court had the opportunity to dismantle what they've done since 1937 with regard to federalism. I think he's right. This case continues with the law's been since 1937 in terms of the court deferring to Congress when it comes to social and economic policy. I think it's a good thing. But I think underlying this is two different views about federalism that have been around since the beginning of the country. A view that says we need to equip the national government to deal with national problems, and one that really emphasizes states' rights. And throughout American history, conservatives have tried to defeat progressive efforts by invoking states' rights. The opposition to the abolition of slavery was done not by the defense of slavery, but by invoking states' rights. In the late 19th and early 20th century, progressive federal legislation, like the child labor law, was defeated by invoking states' rights. The opposition to desegregation was done in the name of states' rights. So if we're going to talk about that vision of constitutional law, let's associate it with what it's always been about. Finally, why did John Roberts vote the way he did? I think it's because he believes that it really is a tax in the scope of Congress' tax and spending power. And I think it's insulting to him to apply anything else with no evidence to support that.
Anyone else? Jess?
Well, just to add to the...
Put the mic a little closer.
Thanks. I mean, you know, just to add to the tax question, I mean, there were two versions of this bill, one in the House and one in the Senate, and the House version used the term tax, and it was unclear, I think, when the Senate passed its version, which word was going to end up in the final measure. And in fact, a number of the messy parts of the law were because this was one of the bills that was in progress in one of the houses of Congress. But when the Democrats lost their supermajority in the Senate, to their surprise, in early 2010, for procedural reasons, they were frozen into the version the Senate had passed. So the presumption that the many members of Congress had that they were going to work out these things in a conference committee as they normally do and then come up with another bill was over. The only way they could, if the Democrats could proceed, would be to pass the version that the Senate already had passed. The House would have to pass it identically with no changes. So the same provision that the Chief Justice said fell under the taxing power, which was labeled a penalty, was in fact labeled a tax on those failing to carry required minimum coverage. So Congress actually used the term interchangeably, and it's sort of a historical accident that the one called penalty arose. It is true that, though many people on Capitol Hill thought that they wanted to stay away from the word tax, and I actually found, maybe because you're, Irwin, because you also have a political science appointment, you can explain this. What is the rationale for believing that Americans prefer to be penalized by their government to being taxed? I didn't understand why that was considered a better political move.
Should we turn to a question? We'll let that one hang.
All right.
I'll use the moderator's prerogative to ask the first question. This is directed, I think, mostly to the journalists on the panel, but anyone can answer. Jan Crawford's, the link to Jan Crawford was unusual in the sense that it was contemporaneous with the decision. Usually we find out what happens at the court, but it's many years later. What explains a justice or a clerk, I assume that's where it had to come from, or more than one of those, going now to the media? For what end? And is it likely to have any impact on how the court actually decides cases or does its business?
Okay, I'll try that one. I don't have any inside information on the motivation of the leakers. I think from where most people sit, I would think that it appeared that they wanted to undermine the credibility of the decision. And I think they also wanted to show they were really angry about it. But I don't know why they would do it. It was highly unusual, and I'm not even sure it had to come from a justice or a clerk. And I don't question Jan's reporting. I think she has very good sources. As far as impact in the long term, I think in the short term it has an impact, but as I was told, the justices left, most of them left for the summer to go to some really nice places to teach abroad. And they have been through something similar to this after Bush v. Gore. There was a lot of dissension and unhappiness. I've used for the Roberts Court my barometer for when the court is severely divided. The last day of the 2006-07 term when they handed down the school race cases. And it was so obvious how divided they were and how unhappy and angry the justices on the left were for what that opinion did. But they did get over that as well. I have no reason to doubt when every single one of them says that this is, one of the most collegial courts, that they will find a way to work together in the fall. The fall is going to be very unusual, and it's going to test that collegiality once again, because the court has already agreed to take up an affirmative action case. Race divides this court. Race is what divided it in that most unhappy day on the Roberts Court in 2007. There's also the potential, I'm almost certain, they're going to take a case related to same-sex marriage. The Defense of Marriage Act cases have already come into the court, and I think they're going to have to take one of those cases. And so that also may divide them. So I think maybe we'll get an idea this coming term how they're going to put it back together again. But I can't believe, these are adults, and they've worked together a long time, and several of them have great senses of humor. So I have to believe that they're going to do it. This is the branch of government that seems to be working. So I think we just have to wait and see. I think next term is going to be a real test.
Well, I would just say, I certainly wish I had a GPS tracker on Jan Crawford's car on Thursday, because they might have helped us if we had traced her movements to see where this came from. But there is one, though, I think, critical difference between the Affordable Care Act case and the other recent contentious ones, is that we have a different group of losers. And I don't know that they will react, the same way. The liberals, they're basically the Washington Generals of the Supreme Court. It's their job to lose on the big ones, and they sort of know how to do it. And so this was a role reversal, and I don't know that the Globetrotters are going to be so content with losing that game. Still, there are only 9 votes, and therefore they need to get along. They have no choice. The only dynamic, the sort of the speculative dynamic, I think, to look at is, as most of us here sort of see this evolving towards being the Roberts Court, it seems that the Chief Justice is more motivated to take votes where he finds them from either of the factions, and that to the extent that he has a peculiar vision of the Constitution and the law, and is willing to shape it, creating new coalitions, that might be what we see. But I don't think there's going to be any change in the fact that you know, that the most important constitutional principle remains that. So, and we need to, you know, and they all know that.
Let's open it up to questions. Yes.
This question's, I guess, directed primarily to Jennifer. I really appreciated the way you characterized the Arizona immigration decision as a legal victory, which it certainly is for those who believe in federal primacy. But what I have to say, I find the decision very worrisome on a practical level. I wanted to know what we thought a little more about this. I mean, if a cop stops me in Arizona, he's not going to think that I have an immigration question. If he stops the people sitting up there, but there's lots of other people that they think they will stop. I don't see how you could possibly enforce Section 2B without having racial profiling, and they seem to have sanctioned racial profiling. Feel free to disagree with me.
I'm actually not going to disagree with you. I think that it's impossible for me to visualize how this law is implemented on the ground, how 2B is implemented on the ground without racial profiling. So how do you develop a reasonable suspicion that someone's immigration status has lapsed? How do you develop a reasonable suspicion that someone's student visa has lapsed, or that someone never had a student visa to begin with? How do you assess those things by looking at a person? These are not assessments that can be made by looking at a person, so there will be reliance on certain factors in order to, I think, assist law enforcement in making those preliminary determinations and developing the reasonable suspicion. I assume that race, skin color, class, and accent language will be primary drivers of who is presumed to be out of status and who is not. And then I think that it's, to a certain extent, the decision minimizes the burden that this will put on people who are having their immigration status determined during these otherwise lawful stops. And I think that's something that will be the subject of litigation. The court was very careful to suggest that detentions couldn't be prolonged while these inquiries were made, that perhaps the inquiries could be made after individuals had been released. But I think that as a practical matter, you will have instances, as you do with drug-sniffing dogs, for example, where detentions are effectively kind of stretched and prolonged, and that will happen, that those kind of burdens will fall particularly on certain groups of people. So I think we'll see litigation around that issue. I think we'll see equal protection challenges. I think we'll see Fourth Amendment challenges for unreasonably protracted detentions, and I think those sorts of things can't be avoided in the implementation of Section 2B. I think the other thing to kind of keep in mind is that the decision in kind of fleshing out 2B really kind of talks about the fact that there's at least the federal immigration officers make these determinations, and we have case law on this, Brignoni Ponce from 1975, saying things like Mexican appearance in conjunction with other factors can be the basis for a determination that an individual lacks status, and that's a determination that the court was comfortable saying that immigration officers could make, given their superior training, et cetera, et cetera. This decision kind of elides the distinction between trained officers and state and local officers who have no training in immigration enforcement, and suggests that everybody can kind of do this and make these calls. So I do think there will be litigation. There will be a lot of interesting developments in the future.
Yes, go back.
Professor Chemerinsky, most of the pundits predicted that the Health Care Act would be overturned. You were one of the few that did not. My question is, were you surprised the way it was decided?
I wouldn't have been surprised by anything the Supreme Court did. My own prediction, which I said on many occasions, was I thought it was going to be 6-3 to uphold the law, or 5-4 to strike it down, with John Roberts writing either way. And I predicted if the court was to uphold it, they would do so on the basis of the taxing power, because it was an easier argument. But had the court 5-4 struck down the individual mandate, I wouldn't have been surprised. I do have to say, I would have been surprised had the court struck down the entire Patient Protection Affordable Care Act, which is what the 4 dissenting justices wanted to do. I thought if they were going to strike down the individual mandate, they would then say some provisions that are linked to it were invalidated. I was surprised that the 4 justices in dissent would have invalidated the entire act, and this would have been the first time since 1937 that a major federal social welfare or economic law had been struck down by the Supreme Court.
I actually have a question that came in on email. You'll know it's email, not Twitter, because it's longer than 140 characters. But it's related to the health question. So maybe Bob or Irvine or any of the panelists want to come in on this. Why did the more liberal justices vote to limit the expansion of Medicaid? What are the likely implications of this? Or might this aspect of the ruling be so narrow that for practical purposes it will only apply to this case? And the questioner also asks whether, given what Robert said about the Commerce Clause and the necessary and proper clause, whether he strayed from his conservative principles on the taxing question.
I can take that.
Just use the mic.
I think that the spending clause limitation probably will prove to be very narrow. I mean, if you actually read the statute and understand what it does, the percentage of funds being withheld from the states, I mean, it's basically what Congress did is to say to the states, look, you've got to massively expand your Medicaid program. You know, there are Medicaid funds to get them. You have to do this, covering many, many, many more people. And if you don't, it's not just that we're not going to fund the new Medicaid expand. We're going to take away all your Medicaid funding. If you were to look, I mean, Medicaid fund, this is an enormous amount of money. So it's 100%. And it's just untold millions of dollars, and no state has a realistic choice. You could not turn down that money. Why? Because if you did, you'd have to, let's say California turned it down, you're turning down all this federal money that's coming back from you, and you taxpayers have paid that in their federal taxes, then you have to make up the money by imposing more state taxes. So politically, it would be suicide. And so I think this is an extreme case, both in terms of the percentage of funds being threatened to be withdrawn and the dollar amounts. And as I mentioned, I think the court is just going to have to work this out on a case-by-case basis. My prediction is, particularly with Breyer and Kagan, are going to be very deferential to Congress. They're basically saying, you know, just try to be a little more reasonable. Although, frankly, if you read the spending power cases, there have been past cases where Congress has imposed pretty draconian punishments on states that might be considered coercion. The No Child Left Behind Act is one that pops into my mind. But I was candidly surprised that particularly Kagan peeled off. But again, I think it's going to be a very narrow exception. I think the Commerce Clause is going to be a very narrow exception. It's rare. Congress has never ordered people not engaged in commerce to buy products or services. And so, you know, you draw a line in the sand, but that's not going to affect that many statutes. You got to agree with something I said earlier. Throw me a bone.
I agree that I don't think what I just said about the Commerce Clause is likely to have much effect. It's not very often that Congress compels economic transactions. I think it's even less likely after the controversy of the Affordable Care Act. On the other hand, as to the Commerce Clause, what the Supreme Court has done for the first time is say that Congress can't regulate inactivity, only activity. I worry whenever a court draws a distinction like that, it's an open invitation to lawyers and to litigation. Let me give you an example. Title II of the 1964 Civil Rights Act, which was adopted by Congress in its commerce power, prohibits hotels and restaurants from discriminating on the basis of race. Is a hotel or restaurant that refuses to serve African Americans engaged in inactivity, or is it activity? Now, I don't think the court's going to strike down Title II of the 1964 Civil Rights Act, but I do think it shows how much turns on characterization when distinctions like this are drawn up. I think that the part about the 10th Amendment and commandeering the states is going to lead to a tremendous amount of litigation, but I don't know what's going to be the outcome of that litigation. This is the first time the Supreme Court has ever found that conditions on states are so coercive as to exceed Congress's power and to violate the 10th Amendment. Bob's right, it's an enormous amount of money for the states, but it's also an enormous amount of money for the federal government, which then says, well, why can't it say if a state takes the money, it has to meet the conditions? The key is that the Supreme Court said that this is unduly coercive of the states. Chief Justice Roberts' exact word was dragooning of the states. But he doesn't offer criteria for when something's unduly coercive. Think of the Solomon Amendment. It says that if a law school refuses to allow the military to recruit within the law school, then that university will lose all of its federal funds. Is that unduly coercive? Or there's a federal law that says that if any part of a university discriminates based on race or gender, not that part or program, but the entire university loses all of its federal funds. Is that unduly coercive? Or your example of No Child Left Behind, that puts so many strings on the grants to state and local education programs, and the federal government isn't compensating all those costs. Is that unduly coercive? I think you're going to see a wave of challenges to a large number of laws, and I don't know what's going to happen in the Supreme Court with them.
Yes. I'd like to go back to the SB 1070 case for just a moment. I'll just start by saying I think it's bad policy, but the legal questions are something different. And as I understand the majority opinion, when they upheld the part of the law that they upheld, they said we're upholding it as written, not as applied, and we're not cutting off the potential for a challenge to the constitutionality of the statute as applied, correct?
That's right.
And then the other thing, to envision how it might be applied, police, as it stands, when they arrest someone, are obligated to ask, what's your country of origin? What is your citizenship? And one of the reasons they're obligated to ask that is because if they arrest a foreign citizen, they're supposed to offer that person the opportunity to contact their embassy. So this is not a far cry from what police are often doing or are supposed to do as it is. To have a little card like they used to walk around with to make a Miranda warning that says, ask these 5 questions of everybody that you arrest, I can at least envision that that might not be profiling, that might be constitutional. What do you think?
I think that there'll be a great deal of training around this issue, right? And that will be kind of a fundamental part that determines how much litigation and where the litigation is, how departments train their officers to implement the law. And certainly, I think one of the things that most departments will seek to avoid is a lot of litigation around profiling. So there'll be protocols about how you ask about country of origin, et cetera, in order to make these determinations. The difficulty is that determinations of immigration status are not always simple. They can sometimes be incredibly complex. And so you have individuals who maybe have temporary protective status and aren't in the federal databases listed as such, who will be detained for long periods of time while those sorts of issues are sorted out. They may be individuals whose asylum applications are in the pipeline. There may be individuals whose green card applications are in the pipeline. But there are a variety of people who have some form of twilight status, millions of them really around the country, where these determinations are not kind of on or off style determinations. And so then the question is, well, who gets detained for lengthy periods of time when those determinations are murky? And I think there is where we're going to see it's difficult to train around that and some of the impulses that are driving this law. And I do think it's important to kind of flag the backdrop of some of the impulses that are driving this law, because this law doesn't come in isolation. It also comes in conjunction with a number of other laws, including laws to prohibit the kind of a Mexican-American Studies program, some kind of a wave of efforts to promote English-only legislation. So there's something more going on here than simply immigration regulation. And I do think that those kinds of motivations will bubble to the surface as it's being implemented on the ground.
So I just want to throw in a very quick point on this. You know, the court previous term upheld another Arizona immigration statute, this in the Chamber of Commerce versus Whiting case, where it upheld the state's law that pulled business licenses and even corporate charters from employers that repeatedly hire illegal immigrants. In this case, of course, the court made a big deal of the fact that the federal immigration statute requires the government to respond when local officials seek information on immigration status of people they detain. And so I think the court in both cases was really looking to what Congress has said here and, in its view, applying that statute. And with the Section 2B issue, it seemed that the court was saying, well, if Congress, why is it that only an officer can make an ad hoc decision to check immigration status? What's wrong with the officer's employer just establishing a policy to always do that? In other words, why? I mean, that was the government's argument, that officers can make ad hoc decisions, but the sovereign that employs the officers can't make a policy decision to always do that in the interest of the state. So it seems that, like you say, as a legal matter, the court would say they're not. They're trying to follow what Congress said without regard to whether it's wise or unwise policies, as we had in Justice Kennedy's inspiring conclusion to the Arizona case at the end, assuming the God bless American part.
I'm seeing some questions about both the affirmative action case that the court's taking and also a bunch of gay rights cases that are on their way to the court, asking about what the court is likely to do in the next term. So if anybody wants to, instead of looking backwards, look forward, talk about these issues as they come to the court the next term. Or not.
Maybe now's the time for the penalty versus tax question.
Last year, I think both Irwin and John Eastman predicted that the court would uphold the Affordable Care Act. You're batting 1,000. So.
On affirmative action, I think the Supreme Court is going to substantially cut back on Grutter versus Bollinger, if not overrule Grutter versus Bollinger. The race case that Marcia referred to, parents involved in the community schools for Seiu School District Number 1, was a 5-4 decision. Chief Justice Roberts wrote an opinion, which was joined by Justice Scalia, Thomas, and Alito, saying the Constitution requires colorblindedness. And he did so in very powerful language. That leaves no doubt where these 4 justices are going to be, and I think they will vote to overrule Grutter versus Bollinger. Justice Kennedy in that case concurred in part and concurred in the judgment in part. He said that while diversity is a compelling interest, the government can use race as a factor only if it can show that no race-neutral means can achieve diversity and desegregation. I would not be surprised to see the Supreme Court do something like that with regard to the case that's before it, Fisher versus University of Texas at Austin. Also keep in mind, Justice Kennedy has never voted to uphold any affirmative action program and is now 25 years on the court. So I think this is going to be a very significant blow to diversity. And again, it's all about how Justice O'Connor, who wrote the majority in Grutter, is replaced by Justice Alito. And I'll offer, as long as I'm doing predictions, I think the Supreme Court is going to find a right to marriage equality for gays and lesbians. I think Justice Kennedy is going to write the opinion for the court. I think it's going to be joined by Ginsburg, Breyer, Sotomayor, and Kagan. Ultimately, Kennedy has to decide, does he want to write the next Plessy versus Ferguson or the next Brown versus Board of Education? There's no doubt where society is going on this issue. There have been 2 Supreme Court cases in history advancing rights for gays and lesbians. Romer versus Evans in 1996, Lawrence versus Texas in 2003. Both were written by Anthony Kennedy. I think he's going to see this as his most important legacy from beyond the Supreme Court.
I concur on both of those. I agree on Fisher. I think substantial limitations on diversity, and I agree optimistically on marriage equality as well.
What about voting rights? That also may be on the docket next term, and we're all going to be watching to see if the sort of unspoken threat in the court's last voting rights case about Section 5, which is the pre-clearance requirement in the Voting Rights Act for states that have a history of past discrimination, is going to be found unconstitutional. Irwin?
I think the court's going to strike it down 5-4. I hope I'm wrong. This is the provision of the Voting Rights Act that says that as for jurisdictions that have a history of race discrimination voting, any significant change in election practices have to be approved, and it's usually pre-clearance by the Attorney General. Marcia mentions a case from a couple of years ago where the Supreme Court 8-1 ducked the issue by narrowly interpreting the statute, but Chief Justice Roberts wrote an opinion that went on some length as to all of the reasons why it's likely unconstitutional, exceeding the scope of Congress's power, that Congress' authority is remedial, that the problem of race discrimination voting isn't the same as it was when it was adopted in 1965, and the like. I think that Roberts' opinion leaves no doubt, I think, where he's going to be, and I think then where Scalia, Thomas, and Alito are going to be. And then it's again guessing where Justice Kennedy's going to be. And Justice Kennedy's most important issue, as we saw in National Federation of Individuals for Civilians, is federalism and states' rights. And I think this is likely to be perceived as too much of an affront to states' rights to require some states to get pre-clearance. And I hope on this one I'm really wrong in my prediction.
Just a question on that states' rights point. If other than writing a decision finding a right to same-sex marriage, I mean there are much more modest steps that the court could take, and both the First Circuit and the Ninth Circuit opinions in the 2 cases, the Prop 8 case and the Defense of Marriage Act case, were really written to be as narrow as those courts could make them. And isn't it possible, I mean, is the question really whether Justice Kennedy wants to find a narrow reason to respect federalism in the DOMA case, or a narrow way that the peculiar instances of Prop 8 fall under Romer v. Evans rule, and avoid the bigger question? Or do you think that this is my big chance to really get my name out there, and he's going to go all the way?
I wouldn't be surprised to see the court strike down Section 3 of the Defense of Marriage Act without reaching the larger question, or affirm the Ninth Circuit that Prop 8 is unconstitutional without reaching the larger question. But ultimately, the underlying issue in those cases, does the state, does the federal government have any legitimate interest in denying gays and lesbians of marriage equality? And if the court writes the opinion, I think Justice Kennedy will, that there's no legitimate government interest in keeping gays and lesbians being able to express love and commitment through marriage, from getting all the legal benefits of marriage, I think that's the clear signal. And even if they don't go all of the way to striking down all of the laws in one opinion, it will leave no doubt where the court's going to be. And remember, in Romer, he said there was no legitimate interest for a Colorado law to repeal laws protecting initiative to protect gays and lesbian discrimination. In Lawrence, he said there was no legitimate interest for a law that made same-sex sexual behavior a crime. I think that's the opinion he's going to write. And however the implications are drawn in this case, I think it'll leave no doubt where the future's going to be.
So he'll just adopt Justice Scalia's dissent, which said this case creates a right to gay marriage. Basically, he just say, accept that.
Well, we are out of time. I want to take a moment and thank Brittany Rodriguez and the UCI staff and the IT staff for putting this event together.